In California, spousal support is either temporary or permanent. At the beginning of your divorce, you want an attorney to fight for you to get the most spousal support that you can during the duration of the divorce. At the end of the divorce, the spousal support will become permanent and may be adjusted up or down. In California, spousal support is mostly about disparity of income. The courts don't look at gender. They don't look at whether one party works and the other one doesn't. It's solely how much does your spouse earn, how much do you earn, and they use a computer program that spits out a number. The duration of spousal support is generally half the length of the marriage, but once you are married between 9 and 10 years, the court then transfers it to be lifetime support for you or for your spouse, or until that spouse has been remarried. Oftentimes in spousal support, parties will be very upset because their spouse refuses to work. The courts do expect you to work if you don't have small children, and expect you to work towards becoming financially independent. So if your spouse refuses to work, we can oftentimes get the court to impute income. Imputing income means that essentially whatever the court determines you should be making, which is at least minimum wage, is put in as your number in figuring out in the computer program how much spousal support that you should get. So we can help fight for you to lower your support when you have a spouse who is refusing to work. A common misconception that people have is that the amount of spousal support that they're ordered to pay is permanent. That's not the case. There's oftentimes changes in your life that would require for more or less spousal support. If you lose your job, for example, you can petition the court to pay no spousal support until you receive another job. If you end up getting a raise, your spouse can go and ask for more spousal support or to have their spousal support reduced based on the disparity of income at that point. I regularly have clients call up and say, I just don't want to pay spousal support. That's all I want, is to not have to pay spousal support. This is the state of California. If you make more money than your spouse, you're going to pay spousal support. Having said that, spousal support is negotiable. And so, for example, you could lump sum pay off your spouse and not pay spousal support beyond that. Also, perhaps you can divide assets and give your spouse a little bit more than you normally would for an agreement that they don't ask for spousal support or that they ask for a reduced spousal support. Spousal support is required in the state of California. I'm regularly in court where the person who's ordered to pay support will tell the judge, if you make me pay this, I'm going to lose my apartment, I'm going to lose my car, I'm going to lose all these things. And the judges will look at them and say, that's the reality of divorce. You need to take care of your spouse and your children, and your lifestyle is going to change completely after this divorce. So every situation in spousal support is unique, and there are arguments that can be made to the judge. They have discretion to give you a lower or higher spousal support. This is where you need a good attorney who understands both yours and your spouse's financial situation and can explain that to the judge and work on getting either the maximum or the minimum spousal support, depending on what you're looking for. So if spousal support is a major concern for you in your divorce, call Schank Family Law. We'll help you understand it, and we will fight for you to get the spousal support that you deserve.